Hey everyone, I'm back again in full effect, and today I want to comment on this controversial Religious Freedom Restoration Act that the Indiana legislature recently passed and that Governor Mike Pence recently signed into law. It's raised a lot of concerns that it's going to end up making it legal for private businesses to discriminate against the gay community in particular based on their religious convictions, and possibly members of other minority groups as well. Now, very quickly, I just want to say that we should all recognize that that danger may not be as pronounced as it seems. The reason is that this RFRA, as these Religious Freedom Restoration Acts, or RFRAs, RFRAs are often called for short, like its other counterparts in, I think, roughly 18 or 19 other states, as well as at the federal level, this RFRA contains language that does limit religious freedom to some degree. I quote from Section 8A and B of the law. Except as provided in subsection B, a governmental entity may not substantially burden a person's exercise of religion, even if the burden results from a rule of general applicability. A governmental entity may substantially burden a person's exercise of religion only if the governmental entity demonstrates that application of the burden to the person is in furtherance of a compelling governmental interest and is the least restrictive means of furthering that compelling governmental interest. End of quote. In other words, the governments can actually use this language in a lawsuit against a particular legal restriction. But, in this case, laws that ban discrimination against the gay community, for example. The government can actually protect those laws, even under this RFRA, this Religious Freedom Restoration Act, by showing that the law furthers a compelling governmental interest, namely preventing discrimination against the gay community, and that the restriction is the least restrictive means of furthering that interest. From what I've read, it doesn't appear that it would be too difficult for the government to make that case in court, and a lot of judges, from what I remember learning in law school, already are not so hot on these RFRAs, these Religious Freedom Acts in the first place, and so they're rather predisposed to try to limit their scope and their reach in any way they can. So when the laws themselves contain language like this, that provides governments with a tool to protect anti-discrimination laws against lawsuits that might be filed against them. So I don't think that this law is necessarily going to do as much damage as people fear. However, I do still oppose the law and other laws like it, again at the state and federal level. The reason is something that I first stumbled on when I was in law school. In my second year, I took a seminar in law and religion, and I actually wrote my final paper on the issue of religious freedom and how much protection it should get under the Constitution, under the First Amendment right to the free exercise of religion. I started out in that course believing that under the law and under the Constitution specifically, you should be able to practice your religion free of restriction from the government as long as it's not hurting anyone else, and that exemptions from laws that may substantially burden your religious conduct and religious beliefs should come more or less automatically. But in the course of doing research for my paper, I stumbled on a counter argument that later eventually convinced me to change my mind on the subject. The argument was this: that that kind of legal standard unfairly privileges and advantages religious believers over their secular counterparts. Consider this scenario, for example. If you have two people in a town, both of whom consider it their bounden duty, if you will, to serve food to the homeless, and there happens to be a municipal ordinance in place, a municipal law that forbids them to do so, then you have to consider, is one of them religiously motivated or not? Let's say one of them is motivated by her religion to engage in this activity, while the other one is just as passionate a believer in helping the homeless, but does not have religious reasons for believing that. Rather, she has made up her own mind on the subject and used secular philosophical reasoning to arrive at that conclusion. Well, guess what? The religious believer would be able to benefit from a judicially crafted exemption from that law, that municipal ordinance that forbids her to feed the homeless on her own. And she would basically have that that legal get out of jail free card that would enable her to continue to operate. Meanwhile, her secular counterpart would be out of luck. She would have to fight up through the political process in order to try to get an exemption for herself, or she would just lose and have to fold up and go home. I think that scenario is fundamentally unfair. I don't see any reason why religious belief, the belief that God said you have to do this, should be privileged in that way over beliefs that are motivated by people, relying on, leaning on their own understanding, as the Bible puts it, and using secular, rational thought to arrive at their conclusions and their beliefs. I don't think that, a government, especially in a democratic society with the separation of, between church and state and so on, I don't think that government has any business putting religious belief up on that kind of legal pedestal and giving it that presumptive across the board advantage while denying that advantage to secular philosophical belief. Now, there may be certain specific instances in which, religious communities should benefit from exemptions from certain laws, but those communities should, lobby for those exemptions on a case-by-case, law-by-law basis, instead of getting this, again, across the board blanket presumptive exemption from those laws. Even with the limitations written into the language of these laws, such as the limits that I just mentioned earlier, I still think that these laws go too far. They also create potential for practical problems as well. In a lot of cases, people might want to cite religious beliefs insincerely or falsely to try to get that get out of jail free card. And judges, who are not trained to evaluate the authenticity or centrality of certain religious beliefs, would really be in the dark. They wouldn't be properly equipped to, distinguish those false citations of to religious doctrines from the genuine ones. So that's another concern that these laws raise. And all of that, of course, is in addition to equally legitimate concerns about discrimination and what have you. I just don't think that government has any business giving people that kind of advantage or that kind of privilege based on the fact that they believe God told them, commanded them to engage in certain conduct that the law happens to restrict or burden. So, I believe in religious freedom, but as the Supreme Court clarified in a decision in a 1990 case called Employment Division versus Smith, that really only goes, as far as the Constitution is concerned at least, that only goes as far as what's called the non-persecution principle. In other words, the Free Exercise Clause of the First Amendment really only protects religion from deliberate, specifically targeted, intentional discrimination or persecution. But as long as the government is passing laws that are not motivated by a desire to harm religion in general or specific religious communities or beliefs in particular, as long as the burden that these laws impose on religious conduct is incidental rather than deliberate, I think that those laws pass constitutional muster and that they should pass legal muster, statutory muster as well. I don't think religious communities should have that get out of jail free card on a systemic basis. It's something they should have to negotiate for on a case-by-case basis. And I'm not too worried about most religious believers being able to get the exemptions that they legitimately need, because religious communities actually tend to have a lot of clout in American politics, as I also learned in that law and religion seminar in law school. And, generally religious communities are more influential politically than people realize. And a lot of Americans are very sympathetic to their concerns right off the bat. And so it's actually not that common for governments to go out of their way to persecute religious belief in this country. It happens, but it's not that common, and it's something that religious communities are generally able to fight back against. So I think the political process is the right place for that lobbying to go on, rather than the judicial process. And so for that reason, I think that these kinds of RFRAs, including Indiana's, are a bad idea. I think that they're not justified on a principled level. And they really, for that reason alone, they ought to go over and above any discrimination concerns that they may engender. So that's my 2 cents on this issue. And again, agree or disagree, or whether you agree partly and disagree partly, feel free to let me know and share your thoughts with me. I look forward to the discussion as always. Adios.